Law of Trust, Part 5, Unlawful Purpose. Today we will continue to see the topic of unlawful trust. Before we continue this today's subject, we will brief what we have done in the last lectures. Section 4 and Section 98 of the Trusts Ordinance require the lawful purpose of the trust created under Chapter 2 and Chapter 9 of the Trust Ordinance respectively. As we have seen in Section 4, generally a trust may be created for any lawful purpose. Even no need to say, but Section 4 reads that a trust may be created for any lawful purpose. The purpose of the trust is lawful unless it is forbidden by law, it is of such nature that if permitted, it would defeat the provisions of any law. In paragraph C, it is fraudulent. Paragraph D, it involves or implies injury to the person or the property of another. Finally, the court regards it as immoral or opposed to the public policy. These are the circumstances in which trust becomes unlawful. But anyway, we have seen that if the trust for two purposes or more than one purposes, then one is valid, another one is invalid. But there are conditions. Section 4, subsection 2 talks about these circumstances or these situations. A trust which purpose is unlawful shall be void. That's very clearly said. The trust may be created for any lawful purpose, and subsection 2 provides that a trust which purpose is unlawful shall be void. Where a trust is created for two purposes, one of which is unlawful and non-separable from other purpose, then the whole trust shall be void. If two purposes can be separated, the trust as whole will fail but shall stand for those objects which are lawful. Then in terms of section 4.2, if the trust for two purposes or more than one purposes, one is lawful, other one is unlawful, at the same time it is separable, then we can give effect to the lawful one and we can declare the unlawful one is void. And also we have seen section, this is in relation to the section 4, that is express trust, because section 4 comes under express trust chapter 2. Unlawful trust and the legal contract are governed by almost similar principles. The Veeramandiri divided the illegal contract into three categories, such as contracts illegal by statute, contracts contrary to the common law, contract contrary to public policy. When we compare section 4 with the classification given by Professor Veeramandiri, then we can identify for 1A, the purpose of the law, purpose of a trust is lawful unless it is forbidden by law. Here we say that Professor Veeramandiri says contracts illegal by statute. Then more or less similar principle here given in the statute as well as in the classification given by Professor Veeramandiri. The second one, when you see here, Veeramandiri says contracts contrary to the common law. It is a general principles, but it may include the B of subsection 1 of section 4 of Trust Ordinance. It is of the nature that, if permitted, it would defeat the provisions of any law. Or even we can say C, it is fraudulent, that is contrary to the common law. Then finally, Professor Veeramandiri classifies this one, last one, classify into three categories, in which we are in last one, that's the contract contrary to the public policy. That is equal to section 4, subsection 1, paragraph E. The courts regards it as immoral or opposed to the public policy. That we have seen in the last lectures. Now today, before you go to the today matters, then we have seen that, then what's the issue now? We say that once the trust is unlawful, then it is void. Chapter is over. Then why we are talking about this topic? That's the interesting point. Once we say that trust is created in terms of section 5 of the Trusts Ordinance, first of all, there must be a deed of trust. And the property, in the case of immovable property, that should be transferred to the trustees. Now, even though in the case of unlawful trust, those two matters should be followed. Therefore, even if it is for unlawful purpose, the deed of trust is created and the property transferred to third party. It seems to be a trustee. In that circumstance, the property now transferred to transferee or trustee. Then the issue here, what happened to the property? Because trust, we say that trust is void. Then what about the property? That's why we must find the way out. We have seen in the Trust Ordinance section 87(1). Some extent, there's a trust arising out of the circumstances, even the trust, another trust is created for unlawful purpose. Where a testator bequeaths certain property upon the trust, and the purpose of the trust appears on the face of it to be unlawful, or during the testator's lifetime, legatee agrees with him to apply the property for the unlawful purpose. The legatee must hold the property for the benefit of testator's legal representative. That means property transferred to another person because of the trust. Here, testator bequeaths certain property upon trust. There's a trust created on the basis of trust, the property transferred to another person. But the purpose is unlawful. In that situation, the legatee should hold the property for the benefit of legal representative of the testator. In terms of section 4, if the purpose of the trust is unlawful, it is void. There is no second word at all. But property had been already transferred to another person. Now the property is in third party's hands. As we know that in our common law, or in terms of common law, that's a Roman Dutch rule or Roman Dutch law, there's a rule is there. No one should be enriched in the expense of another. At the same time, by operation of section 87, the Trust Ordinance, by operation of section 87 of the Trust Ordinance, a trust arising. Now the thing is, under section 5 of the Trusts Ordinance, trust is created, property transferred, but the purpose is unlawful. Therefore, trust is void. But by applying section 87 of the Trust Ordinance, another trust is arising there on behalf of the person who has transferred that property, that is the author of the trust in terms of section 5, but here we can say transferor or maybe testator. Now we have seen whether we can apply section 85. Section 85 is an interesting section because where the trust is incapable of being executed, where a trust, because sometimes we can say that the trust is created, thereafter law is enacted by Parliament, certain purpose because of the enactment of law becomes unlawful. Once again, the trust is created, thereafter Parliament passes a law which prohibits the purpose of the trust. In that situation, trust is incapable of being executed. But anyway, the section does not speak about unlawful purpose. If the section is held not to apply in terms of section 87(1), the trustee of the unlawful trust would hold on resulting trust for settlor in the exceptional circumstances allowed by the maxims of in pari delicto or under section 86. We have already seen section 86. These all under express trust. Trust is created under section 8. The purpose is unlawful. Property transferred. Then the transferor may get the help of section 87, by which he can argue that there's a trust arising by operation of law. Then we have seen, now this is express trust up to now. Then we will see in the case of constructive trust, if the purpose is unlawful, then what is the situation? When you see this one, section 98 of the Trust Ordinance is important or relevant. Section 98 of the Trust Ordinance provides that nothing contained in this chapter shall impair the rights of the transferee in good faith for valuable consideration, that's not the issue now, or create obligation in evasion of any law for the time being in force. When you summarize this section 98, this chapter means chapter 9. Chapter 9 in the sense constructive trust. That's the section that is in the chapter 9. Then the constructive trust shall not create any obligation in evasion of any law for the time being in force. Then first of all, we must see what is known as this evasion of law. That we have seen, there's a intentional attempt to circumvent the existing laws. Not mere touch the law, it does, or touch over, there's a mere violation, does not amount to the evasion of any law. That's why we have seen what constitutes legal or illegal purpose. We have seen, first one we have seen, now we are in the fourth one. First one we have seen, a transfer or the purchase in the name of B, a property, to enable B to institute a legal proceedings, or to seek particular employment, or to stand in for elections as a candidate, finally to act as surety. But the court held that in the case given here, Sinnalepe versus Pathuma, 1921, it has illegal nature of transaction, but is claim. Then we have seen another one, section 2, item 2 here, where A is forbidden to purchase a certain property in his name because he was a government servant, and also government servant should not purchase a property unless otherwise he has a certificate to purchase. But here what he has done is he provides the consideration and purchases in B's name, that is not illegal. Pereira versus Gunawardena, 1911. Then in the Pereira versus Gunawardena, it said that even though there is a violation, but it is not evasion of law. As we have seen in the first case also, there are circumstances given, there are situations given, enable B to institute legal proceeding, to seek a particular employment, to stand as a candidate for election. All these things not an evasion of law. Then what is evasion of law? As the first heading here, what we have seen, to act as surety. That is illegal nature transaction. Then we have seen the third one, a conveyance to or purchase a property in the name of B by A, so that tax on the property would be reduced, is illegal purpose. As we have seen, or you would have studied, or you will study later in the tax law, avoidance of tax, evasion of tax. Avoidance of tax in the sense to avoid the payment of tax within the scope of law. That's not the violation of law. But evasion in the sense violating law, that is an offense at all in the tax law. Therefore, the same way here also we say that evasion in the sense intentional attempt to circumvent existing laws. Then we have seen Saroja Nisanjala case 2011 2 SLR 340. In that case, what we have seen, the issue was there whether a purchase of property by third party for and on behalf of foreigner alleged in order to evade the payment of 100% tax on sale. Now, this is sale could create a trust on the basis of section 4 or section 98 of the Trust Ordinance. It was there, now it was amended, and the Finance Act required to pay 100% tax if a foreigner purchases a land in Sri Lanka, but thereafter the Finance Act amended and repealed the provision, and another act was brought into operation that's known as Land Restriction on Alienation Act, by which absolutely prohibited the sale of land to the foreigner. But there are exceptions in that law. Forget about that part now. When you come to this point, that's why even when you see the section 98 we have seen, nothing in this chapter shall create obligation in evasion of any law for the time being in force at that time, because when the foreigner purchases a property in Sri Lanka in the name of Sri Lankan, there was a law which required the foreigner to pay 100% tax. But anyway, appellant contended that there is a breach of revenue law. Therefore, respondent cannot seek relief of trust ordinance, any relief under trust ordinance. But the court cited that we have seen already. Just I want to refresh your mind now. Dr. L.J.M. Hure, in his work on the subject of trust, has discussed the nature of the unlawful trust. According to L.J.M. Hure, if the sections 4 and 90 of the Trust Ordinance had been omitted, no problem. The general law of the land would have prevented operation of trust for illegal or unlawful purpose. And also the Supreme Court cited the Fernando versus Ramanadan, that's a full bench decision. In that case, the full bench at that time has decided that a deed is not invalid on the ground of illegality because it is contrary to what may be termed the policy of the ordinance. Court stated that no argument were put forward that if it was allowed, the transaction which took place would defeat the provisions of any law. The court said that, once again, the court said that there is no arguments were put forward that if it was allowed, the transaction which took place would defeat the provisions of law. Now, what happened to the 100% tax if a foreigner purchased in the name of the Sri Lankan? The answer is whenever the Sri Lankan transfers this property to the foreigner, at that time he is liable to pay 100% tax. Therefore, even if it is allowed, the transaction which took place would not defeat any provisions, because he has to pay whatever time. In terms of the finance law, If the property is transferred to the foreigner, then 100% tax should be paid at the time of execution of deed. Similarly, no material was put forward to substantiate the fact that transaction is not one which is forbidden by law, because that can be done. Foreigner can give the money to the Sri Lankan can purchase some property, or even foreigner can purchase a property in the name of Sri Lankan. And also, it is not the one which is fraudulent, involves or injury to the person or property of another. Finally, courts regards it as a immoral or opposed to public policy. Nothing is proved, no arguments submitted for this purpose. That's why the court said that finally, Finance Act empowered the commissioner to recover the tax when at the time of transfer, at the time the property is transferred to the foreigner. Finally, the trust is not contrary to the section 4 and section 98 of the Trust Ordinance. Now we are here in item 4. A purchase by a judgment creditor of the property of his debtor at the sale in execution without sanction of the court is unlawful. There's a judgment creditor. He purchased the property from the judgment debtor at the sale in execution by court without sanction of the court. That is unlawful. Therefore, it is in evasion of law in terms of section 98 of the Trust Ordinance. Then the item 5, where C intending to gift a property to A did not do so because A was pressed by creditors and instead the transfer to B. Actually, C intended to transfer or give the property to A because of loans and everything on A. He didn't want to transfer the property to A. He transferred such property to B. On what promise? On B's promise that he would transfer to an appropriate time. It can enforce the trust because it is not in evasion of law. C intended to transfer to A, but A had so many loans and everything, then C didn't want to transfer property to A. Instead, he transferred the property to B on the B's promise that he would transfer in an appropriate time. Therefore, the court said that A can enforce a trust. That means it is not in evasion of law. Now we will move to other slide here. Then the final item here, sixth one, a conveyance to a property of the purchase of property in the name of B by A to put it beyond the reach of A's creditors is unlawful. It amounts to cheating. That's why it is evasion of existing law. Now we will come to the maxim that we have already slightly discussed in the express trust and also in the first point that we have seen in terms of section 4 that we have seen, but now we will study this one in detail. Action on illegal arguments. Actions on illegal agreements are governed by principles expressed by two maxims. Exterbary causa non-oriter action. Exterbary causa non-oriter action. Second one, imperi delicto est poiter est conditio defendendis. Imperi delicto est poiter est conditio defendendis. In short form, we will refer this one as imperi delicto maxim. These are the two maxims given here for the purpose of getting some sort of relief. The first one, exterbary causa non oriter actio, is a Latin term which means from a dishonorable cause. From a dishonorable cause, an action does not arise. The cause of action must be there. The dishonorable cause of action does not create any action. Second one, Latin, imperi delicto poiter est conditio defendendis. If both parties are in wrong, the position of the defendant is the stronger. If both parties are in wrong, then equally wrong, then the position of the defendant is stronger than plaintiff. That's the meaning of these. First, exterbary causa non oriter actio prevents the parties to the illegal transaction from enforcing it by claiming performance or damages. If there's an illegal transaction, the parties are not in clean hands. Therefore, they can't go to the court to get the contract or agreement to be performed or ask for any damages or relief from that transaction, because legal transaction does not create or does not allow to file a case in the court of law. That's why the first maxim, exterbary causa non oriter actio, prevents the parties from enforcing it by claiming performance or damages. Then that is absolutely prohibited. Absolutely, he can't file an action, because parties to the illegal transaction, both parties are in the illegal transaction, then they can't claim any damages or performance. Say suppose, for example, there's an agreement to traffic the narcotic trucks from one place to other place. If the party agreed to do that, first place the parties agreed to that, if the party fails to transfer or traffic, party agreed to do that, but now the party refuses to transfer or traffic the narcotic trucks, can you think that other party can go to the court and ask for performance, specific performance, or even can they ask for damages because it is illegal? Likewise, another example we can take here. If there's a person enters into agreement to kill somebody, then in that case, that's totally illegal transaction, an offense also. But if it is illegal transaction, if it is illegal contract, can the party, can one party go to the court, ask for enforcement, performance? No, you can't do that, because Simply, as we know, everybody know that illegal transaction, illegal agreement cannot be enforced by claiming performance or damages. The second one, pari delicto poiter est contio defendendis, applies to the cases where a party to the illegal agreement is seeking to recover the property which has changed the hands during the illegal transaction, quote, refusing to intervene. Now what happened here? This in pari delicto maxim applies to a case where a party to illegal agreement is seeking to recover the property which has changed hands during the illegal transaction. Generally, court refuses to interfere. But the court has no discretion to grant any relief against the operation of first maxim, because simply, if a party to the illegal agreement or illegal transaction cannot claim anything from other party, because it is illegal transaction. But the second one, in pari delicto, that's a different one. But various exceptions to the application of second maxim have been admitted. All of them referable and subject to overriding consideration of public policy and justice between the parties. Then the first one, there is no exception. Even the court has no discretion to grant relief. That's the first maxim. But the second maxim, there are exceptions. The transferee benefited from illegal transaction. The plaintiff may argue that he is not so guilty as defendant, and the illegal purpose has not been effected. Now the issue is, we must see the section in our Trust Ordinance. When we see section 86 of the Trusts Ordinance, where a owner of the property transfers it to another for an illegal purpose, and such purpose is not carried out into execution, or there's one circumstance, the purpose is not carried out into execution. Second one, or the transferor is not as guilty as transferee. Transferor is not guilty as transferee. That's why here also we say that there's a various exception to the in pari delicto maxim. That's one of that, transferee benefited from the illegal transaction. Then the plaintiff may argue that he is not so guilty as defendant. Not so guilty as defendant. Here also we say that in section 86, the transferor is not as guilty as transferee. Then the plaintiff is not guilty as defendant. That's the thing given also. Plaintiff argue that he is not guilty as defendant. And the third one, the effect of permitting the transferee to retain the property might be to defeat the provisions of any law. Then what happened? The transferee must hold the property for the benefit of transferor. As I told you in the first lecture, 87 When we apply the 87, there is a trust already executed for the illegal purpose. Then the property is transferred to another person, third person. Then in that case, we apply a section 81. Suppose there's a trust created under section 5.1, express trust for the illegal purpose, then come to 87, the transferor can argue that under section 87.1 to create a trust. But in terms of section 86, the owner of the property, there is no trust at all. This is the first time the property transfers. The owner of the property transfers the property to another person for illegal purpose, and such purpose not carried out. Or sometimes the transferor is not as guilty as transferee. In those circumstances, transferee must hold the property for the benefit of transferor. Then in the one of the exception is more or less similar to section 86. Courts will grant relief where the parties are not in pari delicto, where the plaintiff is not so guilty as defendant, or where the illegal purpose wholly or substantially unperformed, not performed. The courts seem to have proceeded on the assumption that the claim of the person who transferred the property under section 83 or paid consideration under 84 fails unless his case falls within the exceptions to the in pari delicto maxim. This is one of the interesting cases. In the case of Eminona versus Vinson, where a judgment creditor had purchased through the nominee B the property of the judgment debtor as rupees 5,000, which is less than the appraised value, that was 14,000, which sum was less than his debts. But A had not sued for the balance of the debt because, really speaking, the value of the property was 14,000 rupees, but the judgment creditor purchased that property from the judgment debtor was 5,000 rupees. Then he had not sued any for the balance of the debt. A's action against the B for the recovery of property failed. Because it was held that illegal act was complete when the property was purchased at the price less than the appraised value. That's why here we have seen in section 86, there's a comparison between transferor and transferee in relation to the guiltiness. That's why here it says, where a owner of the property transfer the property to another person for an illegal purpose, transferor is not guilty as transferee. Here, one thing. And second thing, here we have seen that in section 86, such purpose is not carried out into execution. Such purpose is not carried out into execution, but here A purchased the property for a lesser value. Therefore, the illegal act was complete when the property purchased at the lesser value. That's why the court said it is out. There is no trust at all. The decision followed English authority and inconsistent to the local cases or case law like Muhammadu versus Ibrahim. It is cited in L.J.M. Hurey's book that's known as, the book name is Reception in Ceylon of the English Trust. The L.J.M. Hurey cited that this decision followed English authorities and also it is inconsistent to the local cases. In Muhammad versus Ibrahim, A had conveyed the property to B for no consideration, so that it could not be seized by A's creditor. The court enforced a resulting trust because no creditor was defrauded. No creditor was defrauded. And therefore, the contemplated fraud has not been effected. Now, he was under pressure of the creditor. Then A conveyed the property to the B for the time being, and he has fully paid the creditors. After that, he asked the court to enforce the resulting trust. The court agreed because there is no illegal act carried on. That's why when you see the section also, once again I would like to highlight that section here. Such purpose is not carried out into execution. Here also, the property transferred, but still A paid in full all the creditors. Then no creditor was defrauded. That's why the illegal action, never carried on. The principal factor that influenced the court was the Roman Dutch law rule that no one should be enriched at the expense of another. Another case, year 2 versus Banda, where A had transferred the property to B. A creditor of A sued a criminal proceedings, and during the proceeding A paid the creditors in full. When A later claimed that B held the property in trust, the court seemed to think that A was entitled to the relief because creditor had not been defrauded, since it could be said that illegal purpose has not been carried out. That's similar to Muhammad versus Ibrahim. Sarma versus Muhammad Lebbe, where a person transferred the property in the name of another in order to put it beyond the reach of creditors at a time when the creditors had instituted proceeding against him. Now here, property transferred to another person in order to keep the property beyond the reach of creditors at a time when the creditor has instituted an action in the court of law against him. The court held that the effect of his action was to delay the payment of his debts, and that his illegal purpose was carried out, even if the debt were paid in full. Because the situation here different from earlier two cases, Muhammad versus Ibrahim, another case. Because on those two cases, the property transferred prior to the institution of cases in the court of law. But here in Sarma case, Sarma versus Muhammad Lepe case, property transferred when the creditors had instituted the proceeding against him. Then the court effected, and also court held that the effect of this transaction, the effect of his action was to delay the payment of his debts, and also that his illegal purpose was carried out, even though the debts were paid later in full. In such case, maxim imperi delicto applies. Muhammad's case was wrongly distinguished on the ground of illegal purpose cannot be carried out. That's the idea given by L.J.M. Pure in his work, Reception in Ceylon of the English Trust. He clearly mentioned that Muhammad's case was wrongly distinguished on the ground that the illegal purpose had not been carried out. That's an opinion given by Professor L.J.M. Pure. Finally, the English decision were followed in Sarma versus Lepe, not only derogation in the line of the local authorities, but contrary to express legislative provisions, that is section 86 of the Trust Ordinance. When you see the section 86 of the Trust Ordinance, it's clearly provides that where the owner of the property transferred it to another person for illegal purpose, plus such purpose is not carried out into execution, then the transferee must hold the property for the benefit of transferor. But here in Sarma case, Sarma versus Lepe case, what happened? Even after institution of case, he has transferred the property to another person. He wanted to keep the property beyond the reach, but he has paid all these debts, and therefore, when we apply this section 86, such purpose is not carried out into execution. Therefore, the Sarma case was not consistent to the provisions of section 86 of the Trust Ordinance. Therefore, now when you summarize the whole thing, what we have studied under lawful or unlawful purpose of the trust, the first place we must consider section 4. Section 4 very clearly says or provides that trust may be created for any purposes, any lawful purposes. But there are circumstances or there are situations given under which it becomes unlawful. But at the same time, even though trust created for unlawful purpose, but the next step we must consider, as we have seen in terms of section 5, property already transferred. It should be transferred to the transferee. Therefore, we must get the help of section 87 and create another trust, because there's a purpose of the trust. Even though the trust first place under section 5, in terms of section 5, trust is created. That's why here it says in section 87, where the testator bequeaths certain property upon the trust, and the purpose of the trust appears in the face of the will to be unlawful, the legatee must hold the property for the benefit of legal representative of the testator. When you come to these constructive trust, chapter 9, there's another provision, that is section 98 of the Trust Ordinance. Nothing in this section shall not create any trust in evasion of any existing laws. In evasion, in the sense, we have seen there are six circumstances we have seen under six small heading. Not that heading, that's an item given. The first place we have seen, if a property transfer to act as a surety to another person, then it is illegal. That is in evasion of law. That should not create a trust. There are circumstances we have seen everything at the end. Finally, we have seen that there's three more four cases we have seen. Especially we have to differentiate Muhammad versus Ibrahim and Sarma versus Slipback. But even though the English decision followed in Sarma versus Slipback, it is in derogation of the local authorities like Muhammad versus Ibrahim. And also it is contrary to the express legislative provision section 86 of the Trust Ordinance. That is the end of unlawful trust. Thank you.